Welcome to the debate. So imagine you are investigating a highly sophisticated bank heist.
Okay, bank heist.
Right, and during the course of this investigation, you stumble across a detailed blueprint, but it's written by the bank's own security team. It maps out exactly how to bypass the alarms, how to crack the vault.
Wow.
Yeah, and it even includes diary entries from the architects debating the moral bankruptcy of their own plan. Today, we are looking at a situation very much like that in the tech world. We're examining the legal fortress of OpenAI's fair use defense in the massive multi-district copyright litigation happening right now in New York, which is known as MDL 3143.
And specifically, we are diving into a fascinating collision of two completely different legal universes. Because on one side, you have the explosive evidentiary record that was just unearthed in the California state law trial of Musk versus Altman, which is largely about corporate governance, right? Fiduciary duties.
Exactly, state law stuff.
Right. But on the other side, you have federal copyright law in New York. So the central question we are exploring today is whether the internal evidence of OpenAI's commercial motives, their executive behavior, and structural admissions from that California trial completely dismantles their fair use defense in the New York copyright case.
And to anchor us, our entire analysis today stems from a pivotal new brief filed on May 25th, 2026. Magistrate Judge Ona T. Wong just ordered a massive cross-production of evidence.
A huge order.
Oh, massive. She is essentially taking the sensational, frankly damaging transcripts from the Musk trial and injecting them straight into the copyright litigation. Now, for the sake of our discussion today, I am approaching this from the trenches of high-stakes civil litigation. I'm looking at it through the eyes of a cynical class-action attorney.
Fair enough.
And my position is that this newly produced evidence provides unprecedented litigation leverage. It proves bad faith, massive commercial intent, and verifiable market harm that will systematically destroy OpenAI's fair use defense before a jury.
Okay, well, and I am analyzing this through the strict doctrinal lens of a neutral copyright law professor. My position is that while the optics from the Musk trial are undeniably terrible for OpenAI—
Terribly, yeah.
They are bad. But state law fiduciary duty breaches do not seamlessly overwrite federal copyright doctrine. If you look at the strict statutory interpretation of the Copyright Act, specifically 17 U.S.C. Section 107, OpenAI's transformational use defense remains legally viable, regardless of how messy their boardroom politics got.
Well, if you're listening to this and wondering, why a California state trial about a nonprofit board matters in a New York federal copyright case, you aren't alone. But when I look at Magistrate Judge Wang's May 21st order, which converts that Musk trial record into literal ammunition for the copyright plaintiffs, I see a death knell for OpenAI.
A death knell? That's strong.
I mean it. They have a massive summary judgment motion coming up on August 14th, where they want a judge to just toss this case out. But fair use is fundamentally an equitable doctrine. It is rooted in fairness.
Right, equity.
It requires the defendant to have operated in good faith. In the real world of litigation, when you have a founder like Greg Brockman writing in his November 2017 journal about how to reach $1 billion while actively calling their own nonprofit maneuvers morally bankrupt, the defense collapses.
See, I completely disagree that it collapses, because I think you are letting the sensational nature of a trial transcript blur the actual statutory lines. The Musk trial evaluated commercial purpose purely as a breach of California charitable trust obligations to a donor.
But it proves intent.
They were asking, did you betray Elon Musk's donations? Under federal copyright law, commercial intent is only one fraction of the very first factor of the fair use test.
A very important fraction, though.
But look at recent 2025 precedents, specifically cases like Bartz v. Anthropic and Kadri v. Meta. Courts have consistently held that if the act of training an AI model is deemed highly transformative, then the personal equity stakes of executives simply do not equal copyright infringement.
I see why you think that, but let me give you a different perspective. You cannot surgically separate the objective mechanics of an algorithm from the intent of the people who built it. Not under Factor 1 of fair use, which explicitly asks whether the use is of a commercial nature or for nonprofit educational purposes.
Okay, but
For years, OpenAI's public posture was that their massive data scraping was just for research. But the scale of the admissions from this cross-production is staggering. We have Satya Nadella, the CEO of Microsoft, testifying on cross-examination that there was a, quote, clear commercial element from the outset.
I mean, no one is denying they wanted to make money eventually.
That is a direct admission against interest from their primary financial partner.
I don't deny that Nadella said that or that it looks awful on a slide deck. But does Nadella's understanding of a commercial element legally negate transformativeness? Because the Supreme Court has weighed in on this exact tension.
It absolutely shatters their educational research narrative. Nadella confirmed under oath $9.5 billion in recognized revenue. We have his April 2022 email, this is 7 months before ChatGPT even launched, stating he didn't want Microsoft to be the next IBM.
Right, a competitive tech market.
That demonstrates a clear, aggressive motive to monopolize intellectual property, and it predates any plausible research framing of GPT-4. Furthermore, how on earth can a company claim a nonprofit educational purpose when their former chief scientist, Ilya Sutskever, holds a $7 billion equity stake?
Well,
And he wrote a 52-page memo warning the board that rapid commercialization was overriding their safety protocols.
look, that is a wildly compelling argument for a jury that wants to punish corporate greed. I grant you that. But have you considered the Supreme Court precedents of Campbell v. Ackefros or the recent Andy Warhol case?
Sure, the parody case.
Right. In copyright law, subjective financial motive does not erase objective transformativeness. In Campbell, the rap group 2 Live Crew made a highly commercial, purely profit-driven parody of the song Oh Pretty Woman. The court said it was still fair use because the work itself transformed the original.
But that was a parody. This is a machine churning out data.
The principle holds, though. The fact that Greg Brockman's journal literally asks, financially, what will take me to $1 billion is provocative, yes, but it doesn't change the technical nature of what the algorithm actually does with the scraped data.
I think it does change how a judge views it.
Section 107 of the Copyright Act does not say fair use applies unless the defendant is greedy. It looks at the purpose and character of the use. If training a large language model creates entirely new functional capabilities, the commercial wrapper around that technology is secondary.
I'm just not convinced by that line of reasoning, because you are treating fair use like a sterile math equation, rather than a defense built on equity and fairness. To go back to my opening thought, you are looking at the blueprint of a bank heist and arguing that because the getaway car they built is highly innovative, the theft of the money should be pardoned.
That is stretching the analogy.
The Supreme Court clearly established in older cases like Harper and Rowe that a defendant's bad faith weighs heavily against a finding of fair use. Brockman wrote in his journal, and I quote, "If 3 months later we're doing B Corp, then it was a lie."
Yeah, the optics are brutal.
He admitted it would be morally bankrupt to steal the nonprofit from Elon Musk. This isn't just about making money. It's about deliberately exploiting a charitable status to acquire vast amounts of training data and public goodwill under false pretenses, and then monetizing it. That fundamental deception corrupts the equitable balance a judge has to weigh.
I understand the litigator's desire to paint a picture of a grand heist. It plays incredibly well in a courtroom. But as a copyright purist, I have to push back on the parameters of that analogy. Copyright law isn't a physical bank heist. Data isn't a physical vault that you empty out, leaving the original owner with absolutely nothing.
Try telling the New York Times they have nothing.
But intent only gets you so far. Even if a judge concedes that OpenAI's intent was overwhelmingly, ruthlessly commercial, we still have to evaluate the nature of the use itself and its actual market impact. You can be the greediest executive in the world, but if your product doesn't actually copy or replace the plaintiff's work in the real market, there is no infringement.
Okay, so we're looking at factor 3 and 4 now.
Exactly, which is why we have to look at the actual output of the model, bringing us to factor 3, the amount and substantiality of the portion used, and factor 4, the effect on the potential market.
And that transition is exactly where the copyright plaintiffs now have the ultimate smoking gun: Project Giraffe. This is perhaps the most devastating piece of technical evidence intersecting with the Musk trial.
Explain Project Giraffe for anyone who hasn't read the brief.
Sure. Project Giraffe is OpenAI's internal code-named engineering program. It was explicitly built to implement guardrails against their models regurgitating verbatim copyrighted training content. From a litigation standpoint, let me explain why this is a total nightmare for the defense.
Let's hear it.
If a defendant has to create an entire secret engineering division to stop their product from spitting out verbatim copyrighted text, it is an implicit institutional concession that verbatim reproduction is a core feature of the underlying product. It goes straight to factor 3. It proves they took the whole expression, not just the underlying ideas.
I come at it from a completely different way, and I suspect OpenAI's appellate lawyers will too. Implementing guardrails can and legally should be framed as responsible deployment.
Responsible?
Yes. The U.S. Copyright Office's own May 2025 AI report specifically addressed this dynamic. Attempting to filter out infringement in the output phase doesn't inherently prove that the ingestion phase, the actual training, was illegal. It simply proves the company is taking active steps to prevent copyright infringement when the user interacts with the model.
I don't think a jury will see it that way.
But think about the policy implications. If we legally punish a company for building safety guardrails, we create a perverse incentive. We would be telling AI developers that they are legally safer doing absolutely nothing to protect authors.
That is an interesting point, though I would frame it very differently. Your argument is like a car manufacturer arguing that installing airbags after a series of fatal crashes proves their initial design was perfectly safe.
Well, no, it proves they are fixing a known issue.
They built the Project Giraffe guardrails precisely because the underlying mechanical design is meant to infringe on the exact markets that the plaintiffs occupy, whether that is news summarization for the New York Times or code generation for software developers.
But the guardrails exist to prevent that overlap.
And we aren't just relying on the existence of Project Giraffe as a concept. Magistrate Wang ordered the production of 78 million and 10 million ChatGPT log reservoirs on March 10th. Plaintiffs finally have the empirical data. We don't have to guess if the models substitute for the original works. We have tens of millions of logged interactions to prove direct market substitution under Factor 4.
I mean, the 78 million output logs are certainly the largest data set ever produced in an AI fair use case. I'll give you that. But let's remember what courts actually look for under Factor 4. Factor 4 asks if the secondary use actively supplants the market for the original work.
Which it does.
Look at the Kadri v. Meta decision. That case turned largely on a failure of proof regarding market harm. Meta's primary product, a social network, wasn't commercially substituting for the plaintiff's books. In this MDL, the plaintiffs have to prove that ChatGPT users are using the model instead of buying a subscription to the New York Times or buying a specific author's novel.
The logs will show that.
OpenAI will argue that verbatim regurgitation in those logs is rare. It's idiosyncratic. It's usually the result of a user-prompted edge case. They're essentially arguing that the user is acting as the infringer, not the model itself.
And how can OpenAI honestly maintain that narrative of, rare, idiosyncratic edge cases when Vinnie Monaco shows up to testify?
Ah, yes. The Monaco deposition.
Right. Monaco was OpenAI's 30B6 corporate designee. For those unfamiliar, a 30B6 witness isn't just some guy from the IT department. He is legally designated to speak as the avatar of the entire corporation. When he speaks, OpenAI speaks.
And he did not speak very well.
He showed up completely unprepared for his deposition on Project Giraffe. Magistrate Wang explicitly found that his pattern of objections, quote, impeded, delayed, and frustrated the fair examination of OpenAI. She ordered him back into the chair for 3.5 more hours.
Which is humiliating.
In a civil trial, when your corporate avatar hides evidence about your anti-plagiarism guardrails, that is the textbook predicate for a Rule 37 adverse inference instruction.
That's a severe penalty. A judge essentially tells the jury, the defendant hid this evidence, so you are legally allowed to assume the evidence would have been highly damaging to them.
Exactly. It is a litigator's worst nightmare. A jury will be told they can infer that whatever Monaco was hiding about Project Giraffe proves the model is essentially a piracy machine.
Combine that adverse inference with the $92 billion projected return on investment from the Brad Smith memo, and the factor 4 market substitution argument practically writes itself.
I will certainly concede the optics of a botched 30b6 deposition are uniquely terrible, but optics don't override the statute. We have to pivot away from what a jury might think and look at the procedural realities of how this evidence actually enters the record.
Okay.
Because the strongest evidence in the world is utterly useless if the judge won't let the jury see it in the first place. You are relying heavily on using the Musk trial transcripts as impeachment material, specifically targeting Sam Altman's character to defeat summary judgment.
Absolutely, I am. The impeachment value here is astronomical, in as it structurally breaks OpenAI's case. Summary judgment requires there to be no disputed material facts, right?
Correct.
Sam Altman testified in the California trial on May 13, 2026, under oath. I believe I'm an honest and trustworthy business person. Yet in that same trial, we have 4 contemporaneous insiders, Ilya Sutskever, Mira Murati, Helen Toner, and Tasha McCauley, all testifying under oath that Altman is deceptive or fosters a culture of lying.
It was a brutal week in court.
Murati literally testified that Altman lied about a safety review having been cleared by outside counsel.
Right, but how does skate court boardroom drama translate to a federal copyright claim?
Because OpenAI relies heavily on Altman's sworn declarations to characterize their AI training as a transformative public benefit. Under the federal rules of evidence, specifically Rule 6.8b, which allows you to attack a witness's character for truthfulness, this material completely destroys their narrative.
So you impeach him?
Exactly. If the plaintiffs can prove the CEO is fostering a culture of deceit, his sworn statements about educational intent become highly disputed facts. The judge can't grant summary judgment. He has to send it to a jury. The equitable defense of fair use evaporates when your primary witness is impeached by his own executive team.
I urge extreme caution with that strategy, though. You are assuming Judge Sidney H. Stein is going to allow a massive detour into state law character assassination in the middle of a highly technical, multi-district copyright case. We must look at the structural risks of the MDL.
But Wang ordered it.
Magistrate Wang ordered this cross-production, but a magistrate does not have the final word. Judge Stein is the supervising federal judge, and we already have a very clear signal of how he views these sprawling discovery disputes. Just earlier this year, Judge Stein fully reversed Magistrate Wang on the Books 1 and Books 2 privilege fight.
Ah, the Lisa Blatt appeal.
Precisely. Lisa Blatt argued that appeal for OpenAI, and Judge Stein recloaked OpenAI's internal Slack messages about pirated training sets, finding they did not waive attorney-client privilege. Stein is reading OpenAI's evidentiary objections incredibly seriously.
Sure, he's cautious.
He is willing to overrule his magistrate to protect the boundaries of the case. If you try to drag in days of testimony about California corporate board drama, Judge Stein is highly likely to exclude it under Rule 403. That rule basically says a judge can block evidence if its probative value is substantially outweighed by the danger of unfair prejudice or confusing the issues for the jury.
I mean, I acknowledge the Rule 403 risk.
Stein could easily say, Altman's relationship with Helen Toner has nothing to do with whether a neural network infringes on a copyright.
A judge worried about a circus will shut down the clowns. And Stein's reversal on the Books 1 Slack messages was a blow to the plaintiffs, definitely. But look at how brilliantly Magistrate Wang specifically drafted her May 21st cross-production order.
How so?
She anticipated Judge Stein's strictness. She didn't just grant the Musk transcripts generally. She explicitly framed the cross-production around OpenAI's commercialization efforts, stating in her order that they are, quote, pertinent to the initial factor of the fair use analysis. She preemptively locked in the relevance to factor 1.
That is a clever move.
By tying the Musk evidence directly to the statutory language of Section 107, she made it very difficult for Stein to throw it out on a Rule 72A objection, without looking like he is ignoring the very text of the Copyright Act.
Yes, Wang framed it that way, but framing doesn't bind the supervising judge at summary judgment. OpenAI will undoubtedly cite cases like Thomson Reuters v. Ross, arguing that even among direct commercial competitors, the legal focus must remain on whether the technological use itself is transformative.
They'll try.
And they will point out the fundamental mismatch here. The Musk plaintiffs framed commercial purpose as a breach of obligation running to a specific donor. The MDL plaintiffs are trying to shoehorn that exact same breach into a copyright weight. It's the exact same factual record, sure, but the doctrinal hooks are completely different. The law simply does not always allow you to easily transplant a fiduciary breach into a copyright infringement.
I disagree that it's a transplant. I really do. It's an unmasking. The public posture OpenAI maintained from 2017 to 2019 was a deep commitment to a nonprofit structure, citing broadly distributed benefits to humanity. That was their shield.
Which they leaned on heavily.
Right. But the reality, exposed by the Musk trial, is Greg Brockman writing, conclusion is, we truly want the for-profit. The public posture of Microsoft in this copyright MDL is that they are just an arm's-length investor, and the data training was OpenAI's independent research.
And what did Nadella's email expose?
The reality, exposed by Satya Nadella's April 2022 email, is Microsoft aggressively taking a massive dependency on OpenAI to exert genuine influence at every layer of the stack. We are taking OpenAI's carefully crafted public copyright defenses and impeaching them with their own internal, contemporaneous corporate admissions.
And what happens when OpenAI's legal team successfully argues that their public posture regarding their corporate charter has zero bearing on the physics of their product? What if they prove that GPT-4's ingestion of a New York Times article genuinely transforms factual data into statistical weights, regardless of what Greg Brockman wrote in his diary?
Well, if they can prove that,
Copyright law is inherently insulated by these strict transformativeness requirements for a reason. If we allow a CEO's personal equity stake or an executive's lies to a board member to dictate copyright liability, we jeopardize the entire software industry's ability to innovate. We would be saying that a nonprofit can legally train an AI because their hearts are pure, but a for-profit doing the exact same computational process is a pirate. That is an incoherent standard for intellectual property.
I hear you, but it is only incoherent if you ignore the actual market harm, which brings us full circle. A nonprofit doing purely academic research doesn't project $9.5 billion in revenue by actively substituting the market for investigative journalism and software coding.
That is a fair point.
The combination of Nadella's admissions, Brockman's journal, and the technical concessions of Project Giraffe provides an overdetermined, inescapable record. We are moving into the August 2026 summary judgment cycle with a record of commercial exploitation that is simply fatal to their defense.
Well, while I agree the optics are undeniably challenging and the sheer volume of the factual record is unprecedented, I maintain that conflating corporate greed with copyright infringement is a fundamental error in logic. A judge focused on the mechanics of the law, like Judge Stein, will prioritize the strict technical definition of transformative use over the emotional, equitable, bad faith narrative you are building.
well, we both clearly agree on one thing. The evidentiary record moving into this summary judgment phase is the most developed, anti-fair use record ever assembled against an AI company. No prior group of copyright plaintiff has ever had this level of access to the internal machinery and motives of a defendant.
Agreed. It is a monumental convergence of state and federal litigation, and there are still several looming variables that could tilt the scales in either direction. We are still waiting on the Second Circuit's decision in the Raw Story case regarding DMCA claims.
Oh, right, the Article 3 standing issue.
Exactly. Basically, whether the plaintiffs have the legal right to sue over the removal of copyright management information even if they can't prove direct financial injury. A reversal there could dramatically reopen a whole new front of DMCA exposure for OpenAI and the MDL.
And let's not forget what might surface when Vinny Monaco is finally forced back into the deposition chair for his court-ordered 3.5 hours on Project Giraffe. If he has to produce the underlying engineering documents, the guardrail design memos, and the actual regurgitation rate metrics.
If they have those metrics.
Right. If those metrics confirm what we see in the 78 million logs, the mechanical arguments for Factor 3 and Factor 4 become mathematically undeniable.
It will certainly be a critical deposition. Ultimately, this MDL will force the judiciary to make a profound choice. They have to decide whether the future of copyright in the age of AI should be dictated by the subjective intent and corporate maneuvers of executives or by the objective algorithmic mechanics of the technology itself?
And that is the billion-dollar question. When you look closely at this legal fortress OpenAI has built, you have to ask yourself, does it matter how brilliantly engineered the technical walls are if the architects themselves documented exactly how they stole the land it sits on?
A question that Judge Stein will soon have to answer.
Exactly. Thank you for joining us on The Debate. Keep questioning the architecture. We'll see you next time.